This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. We covered this Taylor Swift appeal and subsequent sending of the case back down to the lower court. And it appears that Sean Hall and Nathan Butler are now going to get a chance to prove that players gonna play, haters gonna hate, that phrase, is somehow copyright protectable, and that Taylor Swift, in using a similar phrase, a very similar phrase, probably even substantially similar, if she committed copyright infringement. The previous judge, the federal district court judge, threw the case out, saying that players gonna play, haters gonna hate, doesn't even rise to a level of copyright protection that deserves a trial or discovery or summary judgment. So he threw it out on Taylor Swift's attorney's motion to dismiss. And then recently something really, really weird happened. The United States Court of Appeals for the Ninth Circuit, who had already ruled here on October 28th, issued another ruling. I've never seen that before. I admit that I don't know everything there is to know under the law. I'm supposed to be good at my research and everything, but I am personally and professionally speechless that the Ninth Circuit Court of Appeals would basically retract part of their appellate ruling in the Taylor Swift case. So then here we have a December 5th filing in the exact same case, and it goes, the memorandum disposition filed on October 28th, right? That's this one. And reported at this location, that's the citation, is amended as follows. At approximately page 639, all text starting with the paragraph beginning with originally as we have long recognized. So let's go find that. Originality, as we have long recognized, is normally a question of fact and not of law. And so Justice Holmes cautioned that it would be a dangerous undertaking for persons trained only in law to constitute themselves the final judges and worth of pictorial illustrations outside of the narrowest and most obvious limits. And then they go on to say that that remains valid, and by concluding that for such short phrases to be protected under the Copyright Act, they must be more creative than the lyrics at issue here, that the district court constituted itself as the fact finder, and it is not the fact finder here yet. Maybe the parties can agree that the judge should be a fact finder. That's called a bench trial, but the fact finder is the jury. The jury finds the facts. So until the parties have a jury trial, the facts aren't found, right? Well, they go on to say in the original opinion that because the absence of originality is not yet established, we reverse the district court's dismissal under 12b-6. So then here, that paragraph, through the final paragraph, concluding with this 12b-6. So this entire page and this entire paragraph have been removed, deleted. Footnote 1 remains and follows the second full paragraph. A clean copy is attached to this order. There has been no timely petition for panel rehearing or petition for rehearing en banc. No further petitions for rehearing or rehearing en banc may be filed. So then they say, since nobody had disagreed with our previous order, we're not going to allow anyone to challenge it further, since we've kind of like revealed our hand that we screwed up. So they're retracting basically an entire page from a 2-page opinion, and the new one reads like this. And let's see if this changes our minds about anything. Reminder that not for publication does not actually literally mean I can't publish it. Not for publication means it is not binding legal precedent. Great way of saying that, right? I mean, it's great that we used the words not for publication to mean something completely different, right? I'm assuming it's archaic language or something, but it does mean not for publication in the summary, the court's report, or the summary of precedential rulings. So now this has been issued as an amended memorandum, and this disposition is not appropriate for publication and is not precedent. That's, again, what publication means. And so it now reads, Sean Hall and Nathan Butler appeal from the district court's dismissal Their complaint alleged that Swift's hit song Shake It Off illegally copied a 6-word phrase. We have jurisdiction, we reverse and remand. So the holding stands, but the reasoning is gone, even though it was never precedential and it was always not for publication. You judges are baffling my lawyer senses tonight. This is a great evening for parties and judges to just completely baffle Leonard French. Like, what the heck? So it continues. The district court dismissed the complaint based on a lack of originality. Any copyrighted expression must be original, although the amount of creative input required is low. It is not negligible. The originality is established when the work originates in the author and has a spark that goes beyond the banal or trivial. Even taking into account the matters which the district court did take judicial notice, Hall's complaint still plausibly alleged originality. And then the footnote stands. Swift argues to this court that they should affirm the district court's decision on other grounds. However, we decline to do so. The district court may consider Swift's alternative arguments on remand. Well, I'm sorry, I haven't seen the Ninth Circuit screw up like this before. Maybe some other attorneys have. I'm really only paying attention to the Ninth Circuit's copyright law rulings, but they really messed this one up if they cited those paragraphs about how the judge should never determine originality, and then it turns out that maybe those cases were overturned or treated disfavorably in the future, or maybe they just went too far, and that page really shouldn't be guiding the judge in the lower court. Instead, the judge in the lower court should be focusing on the originality as explained in this one paragraph. Literally, all that's left of the opinion is this one paragraph. I think that's amazing. So the holding stands, the Taylor Swift case still gets to go before a judge, and we still get a ruling, and the old ruling is amended, and it sort of doesn't have any teeth anymore other than saying, just make sure you evaluate originality, judge. Instead of the previous smackdown that was like, you were improper in evaluating originality. Now it's just saying, you need to do a better evaluation. Just wow. I don't even know what happened there. I'll try to figure it out and maybe put an update or something. But I really don't understand why in the world they would have made that mistake in the first place, unless it was just a overstatement that made it in, and then maybe afterwards some people were like, wait a second, you misinterpreted that, and then they were like, oh, we're embarrassed, we better remove it now, and well, we better foreclose any further complaining about this by just making this amendment and moving on. Okay, I guess eat crow while the crow is young and tender.
Maybe it was a new guy.
Maybe it was a new clerk, yeah. New clerk or a new judge. We've got a second. Let me just do a quick Google search. Ninth Circuit deletes its eyebrow-raising paragraph in Taylor Swift decision. So this is from the ABA Journal. The Ninth Circuit Court of Appeals, reports ABA Journal, has deleted a controversial paragraph from an October decision that had reinstated a copyright suit against Taylor Swift. The deleted paragraph had raised eyebrows because it said disputes about originality are questions of fact, and it would be dangerous for such decisions to be made quickly by a judge. Experts said that approach could limit judges' gatekeeping function, in other words, keeping frivolous lawsuits out of the courts. The deletion does not affect the result, which reinstated the lawsuit, claiming that Swift's Shake It Off lyrics infringed on the copyright to a song called Player's Gonna Play. So that's it. Some legal scholars criticized whether it was proper to limit the judge's gatekeeping function. In other words, if every case that was brought that alleged copyright infringement had to go to a fact finder, the judge would never be able to throw a frivolous case out. And we've seen from some of these frivolous cases how badly the judges really do need to have that power. Could you imagine being a judge? And these judges do not sit on their butts all day. They work really hard. And I mean, they're sitting on their butts while working really hard. You get what I'm saying. They're not lazy. And they need to be able to have ways to manage cases that are frivolous or tenuous or not ripe or are moot. They need to be able to have tools to get rid of cases before they become a problem for the court. Could you imagine yourself having to take hours and hours and writing an opinion, and all the person who you're writing the opinion for had to do was file a case and pay a fee if they can afford it, and file a case that says that they had a copyright infringement claim, and then you have to go through hours and hours of explaining why they never had a copyright infringement claim, because you have to go through a trial and everything. I don't know. No, I see the point. I kind of get it. So yeah, that was interesting, and it sort of explains why the Ninth Circuit would have done that. Why they would have done it in the first place, I still don't know. Why they would have inserted that originality argument, I don't know. It was not a precedential. It was never a precedential opinion, so judges weren't really going to be able to, or lawyers weren't really going to be able to cite it anyway, except improperly. And maybe somebody who's a smarter lawyer than me can explain this in the comments. But let me know what you think in the comments below. Hey, even non-lawyers, lay people, you might have a better, clearer understanding of this than me, because this is just confusing as heck to me, why they would go this far on a non-precedential opinion that wasn't meant for future citations anyway. Don't know. All right, well, that is our show. Thank you for joining me. I am Leonard French, your favorite copyright attorney. I appreciate you putting up with my set and trying to be quiet as my partner is sleeping in the room next door, so I hope I wasn't too quiet, and I certainly hope I wasn't too loud to sleep the slumbering Loch Ness Monster, as Brandon has recently described her. So thank you very much to all of our supporters. This channel would not be possible without your direct financial contributions on patreon.com/ljfrench and sponsors.com/law. Thank you to our December $50 plus supporters: Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen, Rumble in the Bunghole, and Cute Grills in your area. Thank you very much to all of our supporters. The $50 and $5 plus supporters will be scrolling on the screen in front of me, and you will all appear in the description of the videos. Thank you very much for joining me. Thank you very much for watching. Thank you for your support. I love you all. I'm Leonard French, your favorite copyright attorney. Have a good one.